Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys, with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for joining us on this Sunday night. We appreciate you being with us. For the next half hour, we have a panel of experts assembled dealing with the topic that so many of us, all of us at some point, have to deal with this topic and taking care of family and how all that works out. It's a subject matter that I think is going to be of interest to you. Here's how you can be a part of our conversation tonight. At the bottom of your screen, there are ways you can join in, get questions to us. We'd love to hear them. The best questions almost always come from you all. Also, attorneys are standing by live right now. They are attorneys from Hollis Wright. Live, confidential, all fair conversation can take place if you need some legal advice during the course of the show and you'd like to speak with an actual attorney on it. That opportunity presents itself all throughout the show tonight. Now, leading our conversation, he's managing partner of the firm Hollis Wright. Good to see you, Josh Wright.
You too. Hope you're doing well and had a good week.
Doing well. Thank you, sir.
So, nice lead in. You are correct. One thing that is always accurate is all of us eventually are going to pass.
It's going to happen.
What happens after you pass and how your estate is managed and whether or not there's litigation associated with your estate, that's our topic tonight. And it's not a topic we do a lot, but it's a really important topic because it impacts everybody in the viewing audience. And not just that, there is a lot of litigation over what happens once somebody passes away, whether they pass away with a will, whether they pass away without a will, how the statutes protect families, assets, resources, etc. We're going to be talking about all that stuff. And I promise you this. One thing you will find out today, my firm, our firm, and me specifically, we're not experts in this area.
All right.
So we bring in guys like Chris Hamer, who does a great job in this area of the law, and this is kind of his specialty. So a lot of times when we don't, if it's not in our sweet spot, we bring someone that is, and he's got his own law firm here in town. And first of all, welcome. Glad to have you on.
Nice to see you, Josh.
Absolutely. All right, so this is a unique area of the law. How'd you get involved in this area, and how'd you kind of get into this specialty? Because it is really unique.
Well, I'll say I got involved in this specialty really because I helped deal with my grandfather's estate, kind of a family member's estate. I think that's really when somebody understands the importance of dealing with estates in general is when they have to deal with one. Yeah. Everybody hears about doing estate planning and the importance of planning, but until you actually deal with a family member or loved one's estate, it becomes a little bit more important, or you become a little bit more aware. In fact, you see a lot of people jump straight to doing their own planning, maybe after they deal with their mom or their dad passing away.
So how do you explain, I always love to ask this question of folks, how do you explain to people what you do in this area of the law? I mean, it's not just setting an estate up. I mean, there's litigation and there are court proceedings that involve this area of the law every single day, and I know you get involved in some of that stuff. How do you explain kind of what you do in this area of the law?
Well, really what you've got to look at is the reason for opening an estate. And there can be several different reasons. The general reason that most people run into is because there's assets that have to be dealt with. There's either real estate, there's bank accounts, there's property out there that the decedent owned at their death that has to be transitioned and transferred to their heirs. And what you've got to do is you've got to pay the debts, you've got to pay funeral expenses, you've got to determine who the heirs are, and you've got to pay that money out to the appropriate people at the appropriate time. And so that's one reason that you might open an estate. Another reason would be for the purpose of litigation. Sometimes there aren't any assets, but you've got to bring a wrongful death case. You've got terrible circumstances where somebody needs to go hire a lawyer because they've been wronged, they've been in a car wreck, or they've been injured, or there's been a bad device or drug that has taken their life, and somebody like Hollis Wright has got to take some action, and in order to bring that action, you have to open an estate. And so there may not be any assets out there to deal with. The other situation is you may not know whether or not there are any assets, and so you may have to open an estate to determine whether or not there are any assets out there.
So Chris has outlined for anybody that was watching, you don't try and do this on your own. It is really we'll get into this a little bit because I do want to ask Chris about the difference between, if you die with a will and without a will, because that's super important. But it's an area of the law where if you're trying to direct yourself, it's really, really difficult. I think the clerk's offices and the judges in probate will be helpful in a lot of circumstances, but you really need a lawyer to lead you through the process. And truth be told, to maximize the recovery if there's a wrongful death suit, and to make sure that the assets are properly distributed, the debts are properly paid, to save yourself headaches down the road, getting a lawyer involved early and quick is super, super important. Now, I know we get this question a lot, so I'll just ask you, if I don't have a will and I pass away, do all my assets go to the state? And there are a lot of people that think that. Yeah, right. And I think you can probably outline for folks, the legislature and the state was a lot smarter than that. They recognize that there may be circumstances like that, and they've addressed that.
Right, so we've got the intestate succession laws of the state of Alabama, which determine if you don't have a will, where your property goes, or in the case of wrongful death proceeds, where wrongful death proceeds go, because they don't pass under a will. But under the laws of intestate succession, they initially favor the surviving spouse. So, but they essentially follow an order of succession. So, if there's a surviving spouse and there are no children, surviving spouse gets everything. If there's a surviving spouse and no children, but their parents are the decedent, the surviving spouse gets $100,000 plus half of the estate, and the other half is split between the parents of the decedent. If there's a surviving spouse and children who are all children of the decedent and the surviving spouse, then the surviving spouse gets $50,000 plus half the estate, and the other half is split between the children. If there's a surviving spouse and one or more children who are not the children of the surviving spouse, then they receive half of the estate, and the other half is split between the children of the decedent.
So he really just whipped through the entire statute, and that's awesome because it's like you have to have lawyers walk you through this stuff. But if someone's going through this issue, all they have to do is let us know, and we've got Chris that can get involved in answering questions tonight to walk people through some unique circumstance. And there's always a unique circumstance, whatever it may be. There's a surviving spouse, and then a child of the surviving spouse, but not a child of the decedent, or the child is of the decedent but not the surviving spouse, but they passed away just before the other decedent passed away. What happens to the money? Does it go to their children? The good news is this: the legislature in their wisdom has created a series of rules that Chris just walked us through that outline what happens in those circumstances where you die without a will. Your resources, your assets are still protected. However, as we can talk throughout this this event, if you do a will on the front end, you can control a lot more where these assets go, and to make sure that they're properly distributed consistent with your intent. So I know we're getting ready to go to break, but when we come back, I want to talk a little bit about the importance of having a will and how that can impact the setting up of your estate, the payment of your debts, and the allocation of your assets and resources to your family members so you can protect them moving forward, because that's super important too.
That's awesome. All right, at this point, we're going to step aside our first break of the evening. As we do so, reminder of how you can join our conversation. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Times are a-changing, a digital legacy. Welcome back in to the attorneys talking about estates tonight. Would love to have you be a part of the conversation. You see that information on your screen. Also, attorneys from Hollis Wright standing by live right now to speak with you. Just pick up the phone and give them a call. Josh?
All right, so I know we're not doing a show on the importance of wills, but in general terms, explain, Chris, if you can, how someone's after death allocation of their assets and payment of their debts changes if you have a will versus if you die without a will.
Well, if you've got a will, the first thing that you can do is you can name your personal representative. And that's important because your personal representative who you want to serve and kind of manage and control your assets may not necessarily be your spouse or your child, or you may have a second marriage, and so you may want to have somebody else that you trust to handle that. You can also waive bond, waive an inventory and accounting, so you can do some things to kind of reduce costs. You can also name beneficiaries of your estate who aren't your natural beneficiaries or your heirs at law under the statutes that we were discussing earlier. So it may not be that you want everything to be split equally between your children. You may favor one child over another child. I hate to say that, but sometimes that's the case. Or you may want to place some assets in trust because you've got a child that is truly a child and is a minor and can't receive the property, and so you want to set up some provisions to take care of that person, after you pass away, because you're not going to be able to do so in the future. So you can really kind of control the disposition of most of your assets, and you can also select who is going to be in control of those assets and do some things to reduce some costs and kind of make it easier for them to get in place and get moving and start working on getting the estate open and hopefully pretty soon thereafter getting it closed.
A lot of times, I know you've got a question, David. Let me just ask you this. A lot of times people will ask this question. If somebody passes away and they've got credit card debt, does that have to be paid? Does the surviving family member have to pay that, or does the estate have to pay it? That's an important question because we get it a lot. Can you just kind of address that and touch on it?
Right. So unless the surviving family member is a cosigner or is contractually obligated to pay on the credit card, they're not required to pay it. That debt becomes a debt against the estate. Now, ultimately, you may have to get paid if there are assets in the estate sufficient to pay that debt. But there's an order of preference, or really an order of priority, in which things get paid out of an estate. So once the assets are gathered, collected, marshaled, sold if they need to be sold, the first thing that gets paid out essentially is your exemptions. So there's a homestead exemption, a family allowance, an exempt property allowance for either the surviving spouse, minor children, or in the case of exempt property, adult children when there's not a surviving spouse. Then funeral expenses, cost of administering the estate, secured creditors, then unsecured creditors is kind of the order of priority in which things get paid out. So in terms of maybe unsecured credit card debt, if there are assets sufficient to cover those other items, then ultimately the estate will be responsible for paying those credit cards. So if there's not sufficient assets and the estate's insolvent, well then a creditor may not get paid. It's also important to make sure that the creditor actually files a claim against the estate. They're entitled to notice if they're a known creditor, and you also publish notice to unknown creditors because you may not know if there's a credit card out there. And so they have to file a claim against the estate in order to get paid, but they are entitled to notice.
3 words. You know what they are? Hire and attorney.
Right.
Yeah, I mean, if nothing else, listen to that last segment and recognize that you've got to have somebody that leads you through this process without question. I know you got a question, but go ahead and hit it.
That's good. Question we've got here, if I'm named as an executor in a will, do I have to serve, or is there a choice involved?
There is absolutely 100% a choice. You do not have to serve. It is a tremendous responsibility. I will also say that it's a tremendous compliment to be named as an executor in someone's will, but it's a lot to ask for somebody. So if you don't have time, if you don't feel like you have the knowledge or the understanding to do it, or you really aren't up to the task, don't sign up for it and you don't have to. You can renounce your appointment. If there's a successor named in the will, that person can be appointed. If there's nobody named in the will other than you, then the heirs can go and have somebody else appointed by the court.
Who generally can serve in that role?
In the role, first, if there's someone named in the will, it would be somebody named in the will. If there's not anybody named in the will, or if the named person renounces, it's got to be somebody over the age of 19. They can't be a non-resident of Alabama unless a non-resident is named in the will. They can't have been convicted of an infamous crime, and they have to be capable of serving from a standpoint of they can't be incompetent or unable to discharge the duties of trust of serving as a personal representative.
Explain for us too, because I think people need to understand this. If you buy a home, for example, and this actually gets back to this context of what happens after death. You buy a home, a lot of times you're buying a home with a relationship with a spouse where you are joint tenants in common with one another. And as you pass away, does that home necessarily immediately get sucked into your estate? Or if you've bought it through a joint tenancy with a spouse, does that spouse have the right to take that outside the estate and maintain that home?
Right. So homes are a great example. Most of the time, husband and wife own a house, joint tenants with the right of survivorship. That property is not part of the probate estate, so that passes outside of the estate. Similarly, you've got joint bank accounts are not included as property of the estate, and so those would typically pass outside the estate. Also, retirement accounts, pension plans, 401ks, bank accounts with joint or POD provisions that disperse that account to somebody else at the death of the decedent don't typically come back into the probate estate, and they're not subject to claims of
Another good example is, let's take life insurance. I call those beneficiary distributions. So, and I'm serving as an executor right now, and we've had to work our way through the joint tenancy right of survivorship with a home, and also had to work our way through some of the beneficiary distributions. Those are not going to pass through the estate either, because they're dictated through contract who the beneficiaries are going to be. For example, for life insurance, some 401k issues can play into that, where they're outside the estate and can't be subject to and are not subject to creditors that may have certain debts that are collectible against the estate. So having an estate plan is super important, but making sure you have the right person in charge of making sure they know what they're doing to distribute the assets, and to know which assets are supposed to be in the estate and what's not, what's subject to creditors, what's not. Those are all super important things, and why you go to a guy like Chris.
Right.
No question about that.
Time to head to our final break of the evening.
When we come back, let's talk a little bit about who can serve on the non-will side too, under an administration. We also have, in Jefferson County, for example, and many other counties, we have county administrators that are involved, where we deal with the county administrator a lot in cases that involve wrongful death. Let's talk a little bit about that when we come back too.
All right, we're stepping aside our final break of the evening, so take advantage of the opportunity to join our conversation. Also, check out the firm Hollis Wright on social media. You'll find them there as well. Stay tuned, more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WVTM 13.
I think we've made I think things have gotten better than those old days there. Welcome back into The Attorneys. Thank you so much for being with us. Hey, this is our final segment. The attorneys from Hollis Wright standing by for the next few minutes, about 7-8 minutes remaining. So give them a call if you'd like some free, confidential, off-air legal advice. Josh?
So, Chris, talk a little bit about if somebody dies without a will under an administration, and administrator is being set up, who can serve in that role? And how does the county administrator work into that? Because I know you deal with the county administrator and her renunciations or staying in cases a lot, and we do too. How does that process work?
Right. So essentially you've got an order of preference or an order of priority in which the probate judge must appoint somebody. So the first person in priority makes sense. It's the husband or the widow. It's the surviving spouse. The second in order of priority is heirs of the estate that are entitled to inherit the decedent's property. The third would be the largest creditor of the estate residing in the state. If you're in a county with a population of over 400,000 and you've got a general or county administrator appointed, they're kind of fourth in line to serve. And then the next is kind of a catch-all, anybody the probate judge will appoint. There's a provision in the code that says if 40 days has elapsed since the date of the death of the decedent became known, then the surviving spouse, the heirs of the decedent, or the largest creditor are deemed to have renounced their appointment or relinquished their right to serve, in which case the county administrator still isn't deemed to have relinquished her right in Jefferson County. There's a male down in Mobile County, but they have relinquished, they haven't relinquished. So you've got to get a renunciation if more than 40 days has elapsed, even if you're the surviving spouse or another heir. That's not necessarily a difficult thing to do. It does sometimes take some time because county administrators are busy. And the county administrator obviously has the right at that point to serve, but generally will renounce for a family member to serve. But that's essentially your order. It's the surviving spouse, the heirs, the largest creditor, county administrator, or anybody else the court may appoint.
Now, although the code dictates that priority, it doesn't always go smoothly, does it? Sometimes there's litigation associated with this, and I know we get involved in litigation. I know you've been involved in litigation, and a lot of times these things are litigated with a judge where there are multiple individuals fighting over whether or not they should be in control of the estate. You see that quite a bit, don't you?
Right. So you see it with will contest in terms of whether or not somebody that's appointed in a will is appointed under a valid will. You see it in terms of contest where more than one person has applied to be appointed as personal representative or petitioned the court. And then you see a lot of litigation issues that arise after somebody's been appointed, either a subsequent will contest within 6 months of the admission of the will to probate, or issues that arise later between beneficiaries and the personal representative dealing with the personal representative's management or mismanagement of the estate assets. And that's a big issue. A lot of times it comes down to communication or lack of communication by the personal representative. And sometimes it just comes down to really just bad conduct, theft.
Right. So, one of the important things that we try and advise people, especially in wrongful death cases where there's not a will, is that there is generally a definitive period of time within which you can move to have the estate set up before you may lose your right to control that estate, where the county administrator comes in. Again, it only applies to certain counties, and there are a lot of counties that do not have a county administrator. Jefferson County has one, and we work with that individual a lot, and she does a great job. But there is a time frame to this, and sometimes it's advising the family member, look, if you want to be in control of this estate, don't sit back for a couple months and wait. We need to establish and create an estate as quickly as we possibly can. So it's just something that requires you to get a lawyer involved to give you some good advice on that.
We've got about 2.5 minutes remaining, but I want to ask you the most common mistakes you see from folks in this kind of dealing with this area of the law.
The most common mistakes I think I see are a failure to act quickly. So there's a few things that you need to be aware of. A lot of folks will just let this sit for a while.
Right.
You've got 5 years from the decedent's death to probate a will. So obviously you want to act before 5 years if you want to have that will admitted to probate. To Josh's point, when it comes to wrongful death cases, you've got 2 years from the date of the decedent's death to bring that wrongful death case. Not only do you have 2 years to bring the case, you've got 2 years to file the lawsuit, and a personal representative has to be appointed at that time.
Right.
So if you're brushing up against that time frame, you need to get it open.
Time's important.
Plus the assets over time, if somebody's not taking care of those or managing those, they can waste and they can disappear.
We have less than 2 minutes remaining. I want to give both of you an opportunity for a final thought. If you would, you first, please.
Well, and I think Josh hit it right on the head. Act quickly, contact a lawyer. If you're a personal representative or you've lost a loved one and you want to be appointed as personal representative, or maybe you don't know if you need to be or not, act quickly. If you're a beneficiary and you're unsure of what your rights are as a beneficiary, contact a lawyer. There's nothing wrong with asking somebody for advice if you don't know the answer.
One thing I'd say is, I told you off camera, I'm serving as executor right now in my wife's family and administering an estate. And one of the things I learned that I think is very, very important, and I now know why I was appointed, and that is that my role is not to take a position or a side if there's a dispute over a personal effect, something like that. It's to be objective and fair with everybody, all members of the family, because that's what that decedent requested, and that's why they had an administrator, an executor appointed to make sure that things were divided equally. And sometimes, it's equal, even though these family members all get along. Sometimes it's not as easy as you think to make sure you divide things equally. So you got to be objective and fair about it. Chris, thanks for being on. Did a great job.
Appreciate
as
it.
always.
Thanks,
Good job. Appreciate you all being with us. Appreciate you being with us as well. We're out of time, but as we wrap things up, how you can get in touch with the firm of Hollis Wright and return every email and call. So get in touch with them. We'll see you next time here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.